and Zina's in her Crenshaw logo, she actually runs an organization called, it's a long title, the National Judicial Conduct and Law Project. Now try and remember that. And she does a lot of work as a think tank, public policy advocate, and a community organizer working with a lot of community groups. So she has, got a lot of experience to take us through the role of the judiciary for redressing the rights of citizens.
Well, the overriding point of my YouTube interview with Frances is that the judiciary is generally more than other parts of government to average citizens. As we know, the judiciary can't refuse us consideration in the way that a legislator or our executive branch official can refuse our phone calls, ignore our letters, and refuse. So what I want to do today is move beyond those points and address how to ensure that the act we have through the judiciary to appropriate relief. Now, the best or most effective strategies reflect a proper balance between politics and the role of the judiciary in government. A few people have shared with me a thought that's probably very popular, and that's the notion that law and court proceedings are pretty much all, SPN. This idea of you just one opinion versus another, and the winner is whoever can dominate an argument. I think with that impression of their legal system, that is, your opinion versus my opinion, of us to of a legal system, recognize that it doesn't always produce the most fair or ethical outcome, but they see the situation as just one of those things, is to them how life goes. And so what I wanted to do today is address that notion, because I think dispelling that idea will trigger more effective advocacy. And I'm legalistic, but I want us to take a look at a short passage by Professor Drew Lanier. We have a quote from Professor Drew Lanier. He's a gentleman I had the pleasure of being part of a panel discussion about how the U.S. judiciary. And his quote as a passage, it begins, "While courts are certainly political institutions, they are also legal institutions that differ from other political branches. Courts operate within a field of bounded discretion," and that's a key phrase, bounded discretion. And then you can read the rest of the passage. It's up on the screen. And Professor Lanier, he's talking about rules. He says that the bounded discretion is due to these pre-existing rules that govern the decision making of judges. But what I would add is that doctrine or legal principles also limit judicial discretion. They constrain a court's options. So I'll let that passage stay up on the screen for just a few more seconds. Here you go. So we had this passage from Professor Lanier, and you'll be able to access it when the video of this webinar is available. But again, the key phrase that we want to bring out is bounded discretion, and the notion that courts are legal institutions in addition to being political institutions. And I added that while Professor Lanier only talks in terms of rules limiting a court's options insofar as the decisions that they make, I added that it's also doctrines or legal principles that limit judicial discretion. So now we want to move to the situation where courts courts are not following the rules, our doctrine, or that's our perception of whoever's looking at the situation. If you perceive that the courts are not following rules, our doctrine, there is a problem, and that is a problem that deserves public scrutiny. The danger is when we take spin, SPIN, we take spin, our a winner take all approach, and we take that to the court of public opinion and then try to use public scrutiny to control judges. Because remember, those of us who are thinking that it's all about, my opinion versus your opinion is really nothing much other than that constraining the outcome or the discussion, dominating. There are a lot of people who think that dominating the argument is all about survival of the fittest, being the most charismatic, being the most articulate. Well, in politics, the fittest are the people who buy the most TV ads and generate the most voter turnout. And they may or they may not be a majority of a population. They may or they may not support candidates and legislative initiatives that serve the greater good. As we all know, I believe we all know, democracy can get messy and dark, and it can be used to intimidate judges as much as any other public official. But the difference with judges is that our liberty can literally depend on a judge sticking to the rules and doctrine and legal principles, even when the judge, he or she, is in the process of changing the rules or doctrine, because sometimes they do need to be changed. Okay, so we got that basic point. So let's go back to this hypothetical, not too hypothetical, but hypothetical realization that our courts are not following the rules, our doctrine, or at least they're not doing it at acceptable level to the people who are observing the operation of the judiciary in their country, who are getting in the lawless is not performing their, the courts not functioning properly, partial administration of justice. That's the stated goal in the United States. So if you're getting hammered because that's not happening, the webinar stand that you're living a nightmare. That we're living a nightmare. Whoever is experiencing this lawlessness. In fact, when you witness judge after judge, court after court, they're disregarding the law, are playing fast and loose with the law. It's easy to think and legal doctrine are just meaningless, that it's all just a bunch of mumbo jumbo. But I'd like to suggest that when you're thinking that way, that's exactly the time to remember the words that I shared, on the screen of Professor Lanier. Because the risk is if we don't embrace the notion of our courts as legal institutions with bounded discretion, the temptation will focus on people and personalities more than rules and legal doctrine and whether they're being followed and properly applied. Now, don't get me wrong, it's okay to do both. It's okay to talk in terms of the judges and the lawyers as individuals, as well as legal systems and judicial systems. But here's what we confront when our advocacy gets to be all about the lawyers and judges as people, and then that's when we start quoting Shakespeare and suggesting that a good start would be having them all at the bottom of an ocean. You can see there's no big passage associated with this slide. Is just for demonstrative purposes. This is how many people view their lawyer, especially when they're not being plagued with seeming abuses of their country's legal system. the lawyer to many people is like a superhero, saving the. I don't ever get the impression that many people seem to love their lawyer. But when you suggest that all lawyers are bad, someone is likely to tell you, well, let me refer you to a good lawyer. And when the conversation takes on that dynamics, the focus shifts from the problems being with the legal system or with the judiciary to the notion that maybe you're just doing something wrong. Maybe you just don't have a good lawyer. And that thought gets reinforced by the way many people view judges. What you see on the screen is a typical to almost any judge who, for example, provides a keynote address or participates in panel. Included legal reform activists, some very accomplished public interest law professors. I mean, you had some of the most accomplished public interest lawyers imaginable talking about these and persistent abuse of the legal system, and the law professors were, they just thought it was all just too incredible because they were regularly encountering judges at conferences and symposia and cocktail parties, and this is the response they were having. These people are really great guys and guys and gals, and they're smart, and they're ethical. So are not evaluating judges on a regular basis in the context of high stakes public interest litigation, are personal cases with important public interest implications. So when your advocacy seems more like you're hurling accusations than explaining how one or more judges outside their bounded discretion, that's what we seem like. We just, we're judge bashing, we're lawyer bashing. We just don't like lawyers and judges, and we're vicious. It's a very common perception among people who noticing or not being exposed to what a lot of us are perceiving as an unacceptable level of courts failing to adhere to the rules, adhere to relevant and applicable legal doctrine and legal principles. Okay. And again, these slides are demonstrative, just graphics to hopefully reinforce the point I'm making. And the point I'm saying is that, um, it's not that to be an effective legal reform advocate, we all have to come off like law professors, and it's all about doctrine, and it's all about the rules, and we need to be very nice and not be critical on a personal level of lawyers and judges. Some of you may remember Professor Kingsfield from the TV drama Paper Chase. And if you remember that show at all, you would know that he is, and you can look at him and pretty much tell this character, he's not who you want to, kick off your Capitol Hill or Parliament, your protest in front of Parliament. That's not the type of energy that you would want to that phase of public advocacy. So what I'm really suggesting is, yes, we have to have it all to be effective. We've got to communicate and speak effectively to all the audiences that we're trying to reach, and the audiences are very diverse. Some of them have experienced firsthand and on a very personal level troubling troubling use or judicial conduct. There seems to be lawyers and judges who are persistently varying from the rules and the doctrine. Some of us, like me, who are doing this on a full-time basis, and we're monitoring trends across the country, and we're receiving complaints from everyday citizens on a regular basis about their courtroom experience. So we're part of the audience that you're trying to reach, but you're also trying to create awareness among people who are rarely a part of court proceedings, and who have a positive impression of judges and lawyers, or at least they think, or at least some lawyers. And so they think perhaps if you are having problems in court, then maybe it's about getting another lawyer or being a pro se advocate, and doing the job more effectively. So we want, and then you have the law professors who their exposure to lawyers and particularly judges tend to be in an academic setting, and it's just about an exchange of ideas, and the judges, they're very impressed with the intellectual caliber of the judges and their professed commitment to the rules of ethics. Okay. And some of the people that you're trying to appeal to are other lawyers. You're also trying to appeal to reform-minded judges. You're also trying to appeal to legislators because they have oversight over the judiciary. At least that's the way things are set up in our country. Prosecutors. So, this is a very diverse audience who speak, their perspectives are very much impacted by the way they've come to encounter the legal system and judges. And so in order to appeal to these very different audiences, you've got to, one community organizer that I like the way he explained it. He talked in terms of, you got to feed people what they eat. And if you're talking to someone who has personal experience with judges and their tendency to move away from rules and doctrine, you don't have a high threshold of proof. You can say to me, there's a problem, and that's all you have to say, and I'll say, yeah, there is a problem. But when you encounter people who have not had the experience and have not monitored the judiciary in the way that I do, and the way that people like me, then you have to realize that they have a different impression of what's happening. And a lot of people are going to be inclined to think that the problem is perhaps how any of us as an individual, our courtroom encounters, and or whether we're understanding the proper role of the judiciary. So our emotional appeals, they're all crooks and they're just all looking out for themselves, that's going to get a lot of cheers depending on the audience. But even if you are at the rally, and of course you want to want your advocacy to be legal, not defamation, not defaming people or not inciting violence, but you want to get people's blood, boiling about the way their country's judiciary is operating. So you're making these emotional appeals. My suggestion is that you own what you just need to do. Make sure that those appeals are closely aligned with social science and legal analysis, particularly political science, statistics, and well-regarded legal analysis. So, if necessary, couple your advocacy with maybe a think tank that supports much, if not what you stand. And again, keep it legal, but say whatever you're going to say, what you feel you need to say at your rallies or your protests or online. But just make sure that, for example, if you're out at a protest, that you're maybe handing out flyers that include links to your research, and that way you can your message is going to resonate to audience, both who have directly experienced what had difficulties with the court or have dissatisfaction with the operation of your judiciary, and people who either have not thought about it or are at this point pretty satisfied with what they see. I There was a social scientist, and I read his work a while back. I can't even remember where I saw it, but he talked in terms that when people are directly impacted by a problem, you best appeal to them. Emotional appeals are very effective, but when people have not been directly impacted by a problem, then it's logic and objective analysis that's most persuasive with them. And so what I'm saying is that if we keep that in mind and understand that there are going to be people who want to see from you, evidence that courts at an unacceptable level are not staying within, the rules and the doctrine that bind their discretion, that limit their options and so forth. There are going to be some people who, in a very emotional way, with a very low threshold of proof, who are going to say yes. You are going to be some people who are going to want to see your evidence, who want to going to see your statistics, who want to see your whatever other forms of research that you may have to back those accusations, and they want to see it back with some very sound legal analysis. So if coming up with that kind of advocacy is not your wheelhouse, then it may help for you to team up with advocates who specialize in producing that type of data. So Socrates is credited with saying change is to focus all of your energy not on fighting the old, but on building the new. So if you're good at pointing out what's wrong with the old or what's wrong with our current judicial systems, then I suggest that you team up with an advocate and sound alternatives that you find acceptable, if doing that is not in your wheelhouse.
Okay. Can I say to everyone, if you've got questions, points you want to raise, on the chat box on the right, and we'll pick up on any of those. But let me begin by asking you, Zena. I mean, from what you're saying, I mean, the first point that you spend a long time talking about, because obviously you feel it's very important, is that you feel that there is a distrust of lawyers sometimes. And part of your job as an advocate is not just to advocate on the part of the citizen, but to advocate on the part of the lawyer, to say a lawyer can help you, you shouldn't be afraid of them, and you should make this isn't going to the laws, but they go quite a lot in this country, much less. But even in America, you will probably say there are lots of community groups who shy off the legal system, and yet your argument is they should, because the legal system can help them redress grievances.
Yeah, I was pointing out that I wasn't sure if I got all of your question, because it was a bit of an echo or reverb in your microphone, but I guess we were talking about why I encourage us to embrace the judiciary as part of our refuge and citizens' refuge and protecting democracy and individual rights. Is that basically what you're asking about?
Yeah, I'm basically saying that you advocate on the behalf of the lawyers as well. You say to community groups, you should use them. They can be a useful resource. Don't be afraid of them.
Exactly. If anyone is trying to accomplish fundamental reform of their country's legal system or the judiciary, it's going to be pretty close to, I would even use the I word, impossible to do that without having a significant consensus among all the major stakeholders. And so that includes the citizens who are the litigants who are using the legal system, the general population, lawyers, judges, legislators, executive branch officials, all of us have to be comfortable that with the direction that our judiciary is going, and so we all need to come to the table and be able to hear each other. And my personal experience is there's an amazing lack of empathy among those major groups. They're the lawyers and the judges are much, and the legislators are much too inclined to think people who are passionately the way the judiciary operates, that we just don't understand how it's supposed to operate, that we're just disgruntled. And I can attest that no, there's some very uh, very definite associated with the way the judiciary operates in our country. In fact, there's structural deficiencies. But what I see among private citizens, including even lawyers who are reform advocates, they think that anyone who doesn't listen to them or doesn't believe that they're a problem, that they're just simply not honest, or they're too afraid to admit that they're a problem. And sometimes it's just that we have not convinced them that in fact there is a problem.
Finally, take up on the next question, but I just wanted to say this. I mean, your belief that we should be, engaging with lawyers is your belief that lobbying through Congress or lobbying through Parliament very often doesn't get the results, but you can get results by going through the legal system, sometimes faster and more effectively. Is that correct as well?
That's absolutely true. And that's why we need to very much protect that forum and make sure that it's functioning properly, because we have more access to it than any other branch of government. So we need to monitor it and make sure that it's doing its job properly. But we have to do that effectively.
Okay, but there are problems to that, Fong. Do you want to take up Peter's point? Because that's a very real point he's making.
Yes, because Peter had the question about his experience as a small business. You can have with big businesses lawyer because of the prices, the expense.
That's part of a major reform that is necessary. People need to be aware. It's in the industry, it's called an access to justice problem. You have people who just have access to enough affordable, competent, trustworthy lawyers, and this can include people who have considerable amounts of wealth, not to mention people who are impoverished. And so we need to create changes. Some people have talked in terms of simplifying aspects so people can represent themselves more. Some creating more circumstances where you don't have to have since lawyer represent you. It can be someone with perhaps adequate knowledge and practical training. That might be one way of making the system affordable. States have, in our country, have mandated a certain amount of pro bono advocacy, where lawyers are required to provide legal services for free. Those are type of problems with legal system and our ability to provide administration of justice.
How is that, Zena, that you get people who will offer their services free in America? I mean, it's beginning to happen here, and you have a lot of advocacy groups that do work with people who cannot afford to pay for the costs of a commercial. So, I mean, is that a movement that you see is growing? Do you see want to do pro bono work because they actually believe that they are the champions of communities?
Well, as I indicate, in our country, the state judicial branch are requiring lawyers to provide a certain amount of free legal services, but there are limits on the cases that lawyers tend to take on for free, and then you have the legal aid. There are limits to the type of services that they routine and non-controversial and they don't tend to challenge the government. And sometimes when a person is faced with losing their child or losing their freedom through questionable use of family court, family court or criminal court, then they want a lawyer who's willing to come in and suggest that there's misconduct. There's misconduct under color of law. There's government misconduct, and frankly, the policy of our legal aid system here in the United States is that such cases can't be handled, and the budgets of those public assistance programs are being drastically reduced. So we have to become creative in how we fund our protection of rights as average citizens. And I speak. Well, I'm starting to speak more often to people that when they think strictly in terms of, will you take my case? And it's not interested in your advocacy unless you're speaking in terms of, will you take my case? If we don't move, if we don't move beyond that notion, that perspective, this problem of access to justice is eliminating that problem is going to be very difficult. We need to recognize that we need to be creative. We need to think in terms of multi-complainant actions, mutual support, not be disheartened when an advocate is not talking about your specific legal difficulties in your case, but is instead talking more generally about a legal difficulty that involves you, or that you can relate to.
I mean, you were talking about advocating on behalf of lawyers to make people trust them, to get involved with them. But you were also saying you've got to advocate, I think, in your presentation on behalf of community groups to make sure those lawyers are accountable, and that community groups have got to actually do their research, have a think tank sort of operation, if you like, to have the material so that they can keep their lawyers on tap. So a lawyer doesn't go off at a tangent, but focuses very much on what the community groups is trying to achieve. Is that the other side of the coin?
For sure. We have to bring public scrutiny to bear to make sure that the lawyer disciplinary agencies do their job, that the judicial disciplinary agencies do their job. In our country, I help administer an organization that suggests that we should move away on the state level from judicial self-policing, and that task should be part of our legislative branch, but handled directly by private citizens, not blue panel, private citizens, some influential business person that gets appointed and they turn into a rubber stamp, but randomly selected, trained private citizens. So yes, for sure, we have to keep pressure on every source of government oversight with regard to the judiciary, but we also have to champion and protect those judges who want to do the right thing, who are reform minded, because these systems can be turned against them. They can find themselves disciplined, they can find themselves eliminated from their profession, and legislators can find themselves losing elections when they become too critical of how the judiciary is functioning. So when you have lawyers and judges and legislators and prosecutors who are trying to do their job, then as private citizens, then we need to show up for them as well. Another example is when you have a judiciary, family courts are rarely saying that they don't have adequate funding to provide anything other than what I call assembly line justice, sort of, bring them in and you start coming up with a formula as to how, what the outcome should be. So you hear the few minutes of the facts and you enter your decision, and next next, you're not taking the time to really understand the facts. Well, when you hear courts say, well, we don't have adequate budget to do our job, then if our response is going to be, oh, you're not earning them what you're getting paid now, if that's if that's all the response we're going to have. And I'm not saying that response is not understandable to a substantial extent, but we've got to get beyond those type of knee-jerk reactions.
Okay, yeah. I mean, Amy Lynn, I'm not sure where Amy comes from, whether she comes from the States or whether you come from the UK or where you come from, Amy, but you said that on your question, you have an issue when you're facing when a lawyer is being charged with misconduct. She says that she approaches legal advocates to. She's from the US. She approached legal advocates to come to the court hearing with her, but very often they refuse to come because they don't want to be called out to testify should there be a misconduct ruling. So the advocate is only sort of half there. It's only half full, not full. Like a glass half empty rather than full empty. I mean, she's there to help you, but not to help you right up, or he's not there to help you right up in court because of the fear of them being involved in the outcome of the trial or the hearing. Is that something that's quite common in the US?
Oh, for sure. For sure. The fear is palatable and it's justified because, I take more chances than most, but I don't have small children. I don't have children that I'm trying to get through college. So my husband and I, well, he's passed now, but we're willing to be at the forefront. But there are a lot of people who are not, and I hear people say, well, you should just do the right thing no matter what. And yes, that's absolutely true. And people who are inclined to do the right thing, that tends to be their approach. But I wouldn't wish the devastation of a person's finances and their reputation and the future of their family being compromised. I'm not cavalier by asking someone to do that. Particularly when they do that, they're left to their own devices. We have for years proposed legislation that would take lawyer discipline out of the hands of state, which is a more local regulator, and put it in a national body so that the lawyer is not being judged by the peers of the judge that he or she criticize. So to try to create some distance so there's less likely to be local bias, and it's very difficult to get people to be supportive of that legislation, even just in terms of giving you a like on Facebook, but yet and still people are adamantly complaining about the lack of honest lawyers, the lack of honest judges, the lack of bravery. So we've got to, again, hold these bodies and these individuals accountable, never let off. But on the other hand, we've got to champion them. And when they're doing the right thing and when they're taking risks, we've got to be there and say, hey, yeah, this is our guy. We, don't mess with mine.
So we've got to get the balance right, and we haven't got sort of an inbuilt bias against lawyers. We've got to be fairly open-minded. What you're saying, there is, there is. It's interesting in a way. There's a sort of opposite tendency, a dichotomy between the United States and America. I think we face one problem, and you face another. Our lawyers are not elected. So very often they face the charge of being a part of the elite, the metropolitan elite, the people we can't approach. They're not accountable. On the other hand, your judges are often elected, and they face the problem of what some people would call mob rule.
Yes.
They go with the flow because they have both cases, the elitist view and the one that they're victims of the mob. No, subject to the mob are problems that we face, but they both have to face, and how do we overcome
them? Did you ask how do we overcome it?
Overcome them. Is that a problem we've got to live? Is that a problem we've got to live with?
For sure, that's one of the ways that people, especially grassroots advocates who are discontent or dissatisfied with the way the legal system operates and the judiciary operates. That's one of the way that it's so easy to discredit our advocacy and keep us from being taken seriously by saying, well, these are just people who are trying to eliminate judicial independence. The judiciary. Let me just make this basic point. Even though in our country is government of, for, and by the people, our judiciary was never meant to be controlled, by the mob. The biggest, whoever could get the most people together and supporting the position and can control an election. That's why I keep emphasizing that as a legal institution, they're bounded by rules. They're bounded by doctrine. And even when they're changing it, there's procedures. And so when we are talking about the need for reform, we need to be talking in terms of the judiciary complying with existing rules and with the existing doctrine, are changing them in a proper way, as opposed to things such as, oh, we need more conservative judges, or we need more liberal judges. And that's basically people who um, let me put it, when you're trying to control a judge and make a judge rule not in a way that's consistent with the rules and doctrine, but in a way that's consistent with your personal or political or religious perspective, then what you're doing is making improper inroads into judicial independence. Now, don't get me wrong, the rules and the doctrine should be reflective of popular will, political will, the will of major populations, major segments of a population. So, in a conservative or liberal, or they prefer, that society have certain priorities, likely that is going to be reflective in our judicial rules and in our legal doctrine. But it's not a matter of whoever gets together and it can control an election dictates, who should be the judge and how a judge should rule. That is a inroad to judicial independence that my organization does not promote. In fact, we advocate against.
One thing I wanted to ask you is, you talk quite eloquently about the legal system, and you talk about lawyers. You talk about lawyers and who do pro bono work and who work with the community advocacy groups. Can you distinguish to us what the difference is between these lawyers who do pro work is and an advocacy group?
An advocacy group that's comprised of non-lawyers, that's not a law firm, not lawyers, then their advocacy, even though they may be addressing your legal rights, they're talking about the public policy implications of law, or how a court is operating a legal decision. So they're not giving you advice on how to protect your legal rights. They're more talking about implications of how the court responded to your alleged legal rights and the rulings of a court as they relate to the legal rights of discernible groups, segments of a community. So it's the lawyers again are talking about your specific legal rights. They're giving you advice on to how to best protect them. They can make you in court, whereas the advocacy group, we may work with lawyers and bring public awareness to the public policy implications of how a court is responding to legal rights, are even implications of legislation. But we can't represent you. We can't represent you. We can't suggest to you how best to protect your legal rights. Hopefully that makes some sense. It's about public policy and public implications for us.
And
There is a final question. Can we go through it first?
How widespread are these advocacy groups? Are they, can you?
What was that?
Sorry, Francis, is it okay we go through the last question? We are talking about invisible disability, which is beyond.
Question coming. Go ahead.
Yeah, it is beyond the expertise of the judges, and sometimes you can get denied and even punished for cases that the disability is invisible, that they can't see it, so they could deny the person or punish that person. Have you experienced it before?
A person who may have post-traumatic, and they're being triggered by in the courtroom, and so their responses to people who are not knowledgeable about this condition may seem hostile or may feed a negative portrayal of this person that is a large reason why they're being targeted by legal the legal process. They may risk losing custody of their children, and so when you have judges who don't have adequate training with regard to these conditions, or who are not willing to accommodate, allowing advocates who are knowledgeable to participate in the court proceeding and, for example, help keep someone stay calm. These are the things about how our courts operate that the general public should know. And these are public policy implications that people should know about. And we should, to general public and to the legislature, the type of changes that should be made in light of this inadequacy with the court system. And then when you have judges who are deliberately disregarding their obligations to this, then there should be a discipline. And so we need to put pressure on the disciplinary agencies to make sure that, there's a price to pay for being callous with regard to this particular constituency. Is just about active engagement and active judicial oversight.
Question. Peter raised the interesting question of President Donald Trump towards lawyers. He mentions a Hawaiian judge who ruled against his ban on Muslims, and the way in which Trump then ridiculed this judge because of his position and so on. Problem in the States has become a bit of a problem here with Brexit as well, where politicians are now beginning to rubbish judges and rubbish lawyers as well. And I mean, how do you react as an advocacy group to that? I mean, do you take a side on that? Do you, the lawyers against the executive?
What concerns me the most, have an actual judges the Supreme Court with more liberal, the Supreme Court with more conservative judges. What concerns me is that the general public is buying into the notion that these judges are not bounded by discretion, by rules and doctrine, that they are free to come in and make their decisions based on their political predisposition, whether it's liberal or conservative. That's very concerning. And then also, when anyone, whether it's a president or average citizen, are using public scrutiny to intimidate a judge to make a decision outside of the rules and outside of doctrines, that's very concerning. So, if President Trump thinks that a judge is unfair, then he should be free to make that point, just like anybody else should be. But the point should be made in terms of, explaining, making it clear to people that what the judge is doing is outside of the rules, outside of the doctrine. And so when President Trump, hearken to the fact that the judge was Mexican, and that's the reason why he was a person could be force of bias of persons being in favor or disfavor of a politician's doctrine, executive priorities, but President Trump didn't explain it in those terms. He just, took the shortcut of saying, well, well, because he's Mexican. That just simply reinforces what I'm saying, is that when we get personal, don't tie cry for reform in terms of the proper function of a court and the judiciary, and we make it about the individuals, then that's when we're going to not be as effective as reform advocates as we otherwise could be.
Okay, well, let's see, we've gone over the hour, which is great. This is obviously a really, really big discussion. What is really, really important, because the judiciary clearly has a very important role to play. It's a third estate in government. It's protect and citizens' rights. We face lots of problems. The problem in your country of the separation of powers being blurred at times. Problems in this country of our legal system sometimes not being as accountable as it should be, and the elitism, and the need for community groups who want to make use of the law to have advice and help through advocacy. And lots of problems arise in that, lots of skills are needed in that, and groups like yours and the work that you do, Zena, is really, really important. And I know there are groups here in the UK who do the same. And maybe we should follow up this by looking at how different groups are helping out, and maybe you can help us do that, Zena, because if people know where to go and what to do, it would be really, really good.